Welcome everyone to the MSBA ADR spring event and training. I'm Connie Cradaville-Lavelle. I'm the chair of the ADR section for the next week or so, and then Kathy Brissett-Minus takes over. Thank God. So this is the mediation ethics training on implicit bias, race, and mediator awareness. I thought of maybe I'd better say that in case people have logged into the wrong one, kind of like when you get on an airplane and they say, welcome, we're heading to Chicago. So this is the mediator ethics training, and welcome everyone. Wanted to initially thank the members of our planning committee, Stacy Smith, Joyce Mitchell, L.M. Biggs, Aaron Gable, Katie Huff, and Kathy Brissett-Minus. Thank you everyone. We've been working on this for many months, and we're thrilled to death. We have looks like we have wide participation, and we're very excited about that. As always, I feel the need to thank our magnificent and wonderful Angela Monroe with the State Bar Association. She's the section and committee administrator. She's our liaison for everything, for programs, events, budget, and she's my personal life coach. Thank you, Angela. You've been absolutely magnificent this year, and we really appreciate all your help. The ADR section historically does a mediation training every year, and we try to do that every year in order to support our members and other ADR partners, to provide a continuing education opportunity. And when we're identifying and trying to figure out what our topic's going to be, what we try to do is choose a topic that, of course, would be of interest, so we get attendance, something that's helpful, that helps people meet their CLE requirements. But we also try to get a topic that is current and a topic that will be relevant to people's individual practices and perhaps their larger practice on a more macro level of resolving dispute. So this training, as with our other trainings, and frankly with the other work we do in the ADR section, is to support our members in their practices to help their clients and others reduce conflict on a more individual level, but more broadly on a macro level, if you will. Part of our mission for this training and our larger mission is to also help the wider community resolve conflict and identify obstacles to conflict. And obviously, the issue of race and bias is a current topic, and obviously the issue of race and bias is a topic that is rather painful and is clearly creating an obstacle to resolving conflict. And we, the ADR section, and frankly, anyone who is looking to resolve conflict, recognize we have an opportunity for larger impact. And we're hoping that today's subject, implicit bias, race, and awareness, will of course help practitioners, you all participating, will help you in helping your clients and others recognize some obstacles that may be not allowing them to resolve conflict. On a more macro scale, we're also helping that being aware, acknowledging, and recognizing this obstacle, that we can help achieve conflict resolution on a larger scale. Just 10 days ago in Buffalo, the world witnessed another extreme manifestation of this conflict in the race-motivated violence that resulted in mass killing. If we don't acknowledge the obstacle, if we don't talk about this obstacle and other obstacles, obviously we're not going to resolve conflict. In our planning group, we talked about this a lot, and we had consensus on the need for acknowledgement and recognition, and that reticence or silence is complicity. So we will not be silent. We acknowledge racial bias. We recognize this is an issue and an obstacle to resolving conflict on a micro level, on a macro level. We're committed to working towards resolving this conflict so on both the micro and macro level, we can resolve conflict, hopefully in a peaceful and sustainable way. So that's our larger mission. It's our mission anyway, and it's needless to say, it's particularly critical now. And we felt the need to say that. Now, more specifically to this training, there's some other subset objectives to this training. We're hoping people will think more deeply about this subject, examine our own practices. We're hoping this will be an opportunity, particularly in our breakout groups, to learn from the experiences of others that, of course, we're going to encourage everyone to share. And we're hoping that there's going to be some takeaway tips that you all can use and employ in your practices as you go forward. So that's sort of the overview. I wanted to just take a quick minute to introduce our first presenters, if I may. The first is the magnificent Joyce Mitchell, she's also on our section council and has been tremendously generous with her time, with all of the various webinars and events. We've been very busy this year, and Joyce, you've really been an asset, and thank you for coming back on the council this year. Joyce is an attorney licensed in Maryland and DC, an arbitrator, a certified mediator in the states of Virginia and North Carolina. She is a distinguished fellow, that's capital D, capital F, and a member of the board of the International Academy of Mediators, of which most of us are familiar. She has mediated and arbitrated corporate business matters, complex securities, and employment disputes regarding all areas of EEO. Her firm, located in the Maryland, DC area since 1982. And Joyce also facilitates public and organizational disputes. Our second presenter is Professor Luke Fredericks, who Aaron Gable was successful in bringing him in on this training. And Aaron is currently our secretary, and I guess Aaron's is going to be our incoming vice chair. Aaron is incredible. Aaron put together the program, by the way. She's our tech guru, also wildly generous with her time, including when she's probably on the plane coming back from Rome, and she was working on things for us. We're very grateful and lucky to have Aaron as part of our section council. So Aaron is responsible and gets the credit for looping in Professor Luke Fredericks. And I said I wasn't going to say Luke Skywalker. I'm sorry, I can't help it, because we said it in our planning all the time. I know, I won't do it again. He has been an assistant professor at Arundel Community College since 2019. Prior to joining the faculty at Arundel Community College, Luke presented condemned prisoners on Alabama's death row as an attorney at the Equal Justice Initiative, which some of us are knowledgeable about that, and so admire your work, Luke. I mean, you're amazing. He's recently worked with the Maryland Office of Public Defender and served as Georgetown's University pre-law advisor. Before Luke began his legal career at New York University School of Law, he was a Peace Corps volunteer. Of course, he was in West Africa and a teacher in California. And we're honored, Luke, that you're giving us so much of your time to give a historical context to this issue. And I think that's all I got, Angela. If I may, I'd like to hand it over to Ms. Joyce Mitchell. And thank you, everyone.
Thank you, Connie. Thank you for that generous introduction. And hello to all of you. I would like to set the statutory framework for what we are going to do. And if it's okay, I'm going to share my screen to start this conversation with you. Okay, here we go. Share. Can you all see my screen? Okay, here we go. On December 6, the Maryland Court of Appeals adopted, effective January 1, the Maryland Standards of Conduct for Court-Designated Mediators. It replaced the Standards of Conduct which we had before. Today, I want to focus on Standard 2, Impartiality of the Mediator, Standards of Conduct for Court-Appointed Mediators. So what does the standard say? Is that too far up where you cannot see it, or can everyone see it?
We can see it. Looks good, Joyce.
All right. The standard says, the mediator shall conduct all aspects of a mediation in an impartial manner, which means acting without favoritism, bias, or prejudice. And it sets forth 3 areas. The mediator shall decline a new mediation or withdraw from an ongoing mediation if the mediator cannot act in an impartial manner for any reason. A mediator shall not favor or disfavor any participant for any reason, such as the participant's race, age, sex, gender, identity, sexual orientation, disability, appearance, personal characteristic, background, values, beliefs. A mediator shall make an effort to be aware of the mediator's biases and shall learn about unconscious and implicit biases. I think that we should be reminded that this goes to every ADR professional, because these rules replaced rules that refer to arbitrators and other ADR professionals. So what is this thing called implicit or unconscious bias? What are they? The unconscious bias forms our attitudes and stereotypes about things. It affects our understanding about and actions related to association of members, social groups, racial groups, age. These biases can be evident at the negotiation table, the mediation table, the boardroom, and our everyday life. Because these biases often reflect what's happening in our everyday life, they show up when we're at the mediation table. So what causes them? It comes from our associations that we have with our family, with social media messages, with groups. They come from the messages we pick up from the world we live in and our social hierarchies. A simple way I remind myself of a bias is that health-wise, I'm supposed to do green tea in the mornings, but I prefer black coffee in the morning. Now, that's a bias I have toward coffee and a strong black coffee, and I got it from my grandmother years ago. So when I show up someplace, I'm looking for coffee as opposed to green tea. It's a simple bias that my brain has already incalculated that if I'm going to get caffeine in the morning, I have to have it in black coffee and not green tea. Doesn't go to the subject of race, but you can see how simple and how easy it is that our biases, our preferences, and the way we've been programmed walks with us every day as we move forward. How can we determine what some of our biases are? We can come to trainings as we have today. Both Shauna and Tara are going to work with you to help you to see some of your biases, to let you explore them. We all have them. They are automatic. They come precisely from our own brains. The other way is the implicit association test, which you can take. I've bookmarked it here. All you have to do is put in an implicit association test and you will see it. This measures the strength of associations that you have between concepts, and it evaluates the stereotypes to reveal your hidden or subconscious biases. Because we are discussing racial bias, we want to take the opportunity to go to the Project Implicit and just find out what our biases are. I did mine. And it shows that I have a preference for African-American males. Well, I thought about it, it was natural. However, I must have a strong preference for them because that's what the test said. I have a young African-American son. My husband was an African-American male, and so was my husband and my father. That means I have to pay attention to how I treat others who are not African-American males. It doesn't mean that my bias is inappropriate, incorrect, but it's how that bias manifests itself in the mediation session, the arbitration session, or any ADR session that I might do as a neutral. I'll give you a moment in case you want to just write down the word implicit.harvard.edu /implicit again. So I urge you to take the test. There are several other tests you can take, not only on race, but on gender, sexual orientation, and other related topics. As we know, the Crown Act was just established in another state. It's so important that we realize how we see things and how it relates to our current circumstances when we are working with people. Okay, so we have these biases. We can figure out what they are and where they come from, but what are some ways we can address, change, or redirect our biases? We have to think deeply about them. We have to be aware of how they manifest in our private life, our work, and our social interactions. We need to be motivated to be fair and impartial. That's one of the standards of being fair and impartial, but are you fair and impartial if your bias is manifesting itself in your hearing of say in an arbitration forum or in talking with parties in a mediation? Are you exhibiting some form of bias? Now, once you become introspective about things and you think about how your biases are manifest, the next thing goes, will you improve your listening skills, your communication skills? Will you be intentional in your oral statements and your body language? Your body language can give away a lot of your biases. When people are talking to you and you may be doing this, doing certain times they're talking, or you're cringing, or doing other physical manifestations which demonstrate, what I'm saying may not be something that this mediator approves of. The most important thing that I find is the last one. After you think, you be motivated, and you try to improve, is we have to be honest with ourselves. And there's a such thing called being reflective after our sessions. You might even ask a co-mediator only to observe you and you're thinking about a particular subject. You cannot waive confidentiality and talk too much about the session, but you need to be reflective about how you behave. You can identify areas where change is needed. I often do a course when I talk about the quality of the mediator in the room. The mediation process starts with us. We have our standards of impartiality, of competence, of a fair process, of a competent process. But if the mediator is not prepared to look beyond, work beyond, and operate without manifesting his or her biases, the process will not be a fair one for the individuals. It will not be an opportunity for the persons to get a chance to share what they want with us. And I truly believe that if you are not prepared to look at yourself first, you should not be in this area and hold yourself out as a neutral. People come to us and ask for our help, They come to us and they ask for our support. Think about what I've said today and what you will hear the rest of the day, the rest of the afternoon about our biases. So let's get started learning some more about our biases and how it affects our work. The next speaker is Luke Fredericks, who was already introduced to you by Connie, but Luke is a professor at Arundel College, Community College now, and he's going to talk about a subject that your ears want to perk up and listen to, and that's white privilege. Luke, I turn it over to you now.
Thank you so much.
Let me stop sharing, that's great.
There we go. And one moment. All right, so as Ms. Mitchell said, my name is Luke Fredericks, and I am going to talk to you all about white privilege from a policy perspective, an historical perspective, and really white privilege as a foundation to understanding bias. So I'd like everyone to take a moment and picture white privilege. What images come to mind when I say that term? I think for many of us, it's images like this. I think for far fewer people, is it images like this? But my goal today is to help us understand that if we are going to have an honest conversation about white privilege in the United States, we need to think less about this and more about this. So I have two overarching big picture goals for today's presentation. The first is to convey to you that white privilege is not an insult. It's not a slur. And I'll just say that my goal in this presentation is not to make anyone feel guilty, because frankly, I don't think that's productive. Second, white privilege is a concrete historical fact that we'll talk about today. So to that first end, white privilege is not the opposite of hard work. To say that you have white privilege doesn't mean that you or your family hasn't worked hard. It doesn't mean that you've spent your life doing this, right? It doesn't mean you've led a life of leisure. When I talk to people about white privilege, I often get an automatic and very genuine response that relates to people's ancestors. I often hear people say, the moment I mention, white privilege, they'll say, well, my family, my ancestors, we've worked very hard. I've come to a point in my life where I've realized, yes, my ancestors worked hard. There have even been days, moments where I myself have worked hard. But yes, I still have white privilege. Now, to give an example of this and talking a bit about ancestors, I'm not someone who knows much about my family before my grandparents' generations. I'm not one of these genealogy buffs. So as a kid, when I imagined my ancestors, I always imagined the family from the Little House on the Prairie. Right? I know that I have a branch of my family that's been in the US a long time, especially the upper Midwest. And so for anyone who isn't familiar with this book series by Laura Ingalls Wilder, the family from Little House on the Prairie kind of wandered around what is now maybe Wisconsin and the Dakotas. And as I read about this family, sort of my mentally adopted ancestors, as I read about the perennial threat of starvation, as I read about them contending with prairie fires every summer and blizzards every winter, privilege was hardly the term that came to mind. And yet, the Ingalls and Wilder clans were part of the Homestead Act of 1862. So the Homestead Act of 1862 was a government program that began in 1863, went through the 1930s. It says 1988, but really it was just Alaska after the 1930s. And through this program, the federal government gave away 270 million acres in 160-acre plots. So to put that into perspective, that's 10% of the United States. Now, there were some non-white participants in this program, most notably African-American Exodusters in Kansas, really fascinating group, and I recommend reading about them. But they accounted for less than 1%. The vast majority of the people who participated in this program were, like the Ingalls and Wilder clans, of European descent. And this program continues to have ramifications today. 46 million people living in the United States descend from the recipients of this massive, massive government giveaway. So you can see here some documents. The top, we have the Ingalls family, below the Wilder family, their homestead claims as part of this program. Is my point that these people didn't work hard? Absolutely not. To be very frank with you, they were, up at the crack of dawn, toiling in the fields all day. They worked a lot harder than I will ever work. My point is that these folks also worked very hard, right? Enslaved people, later sharecroppers in the South. But they didn't expect the same benefits for their work. They didn't expect that their work would lead to a better life for their descendants. Now, as I said, I do not know the extent to which I actually descend from homesteading pioneers, but I do know that I descend from another iconic brand of American hero, and that is the American GI. I've got military on both sides of my family, and my grandfather, paternal grandfather, served in World War II. He was a medic. He was in both the Atlantic and Pacific theaters. As such, I have benefited indirectly through him from another great American welfare program, what has been called by politicians on both sides of the aisle, the greatest American welfare program of all time, and that is the Servicemen's Readjustment Act of 1944, what most of us know as the GI Bill. As you all know, the GI Bill, after World War II and continuing through to today, helped veterans secure home loans, gave them access to higher education, provided job training. This bill was not racist on its face, but the way in which the resources made available by this bill were allocated was very racist. So for example, if we think about homes, the Department of Veterans Affairs promised to co-sign veterans' mortgages, but allowed banks to deny mortgages to Black veterans. In fact, as we'll see in a few minutes, instructed banks to deny mortgages to Black veterans. So what was the result? Well, let's look at a snapshot. In the summer of 1947, over 3,000 veterans received home loans in Mississippi, and 2 of them were Black. Right? Now, a lot of people hear this and they say, Luke, that's horrible, right? But that's Mississippi, right? That's just what happened in 1947 in Mississippi. I'm not from Mississippi. I've never been there. My family's not from there. Before any of us get, too self-righteous and East Coast about this, in New York and northern New Jersey, fewer than 100 of 67,000 mortgages insured by the GI Bill supported home purchases by non-whites in a period following World War II. So statistically, not much better than Mississippi. When we look at education, we see similar trends, right? 28% of white veterans, only 12% of Black veterans attended college. This was not because of lower demand among Black veterans. This was because there simply weren't enough seats in classrooms that would accept Black veterans. Of the 12% that did attend college, 95% attended in schools in the South that were segregated and underfunded. So for example, there wasn't a single accredited engineering program in an historically Black college in the South following World War II. I mention that for a couple of reasons. One is that engineering at this time was an in-demand profession, right? This is building up to the 1950s, 1960s highway boom, major construction boom. So it was a lucrative, sought-after profession. I also mention it because it's one in which my grandfather dabbled for a time, something that he likely would not have been able to do had he been African American. Job training, we see similar trends. Whites were trained for skilled jobs, Blacks were trained as unskilled laborers. So in one study, whites took 86% of skilled and semi-skilled jobs, whereas Blacks filled 92% of the unskilled positions. This was especially notable in GI Bill related job training dealing with farm laborers. So prior to, or I should say during World War II, 350,000 Black service members came in as farm laborers. Many of them served in the hopes that after the war, they could use benefits to get more skilled agricultural training. Of that 350,000, 1% after the war received skilled agricultural training. So when we look at numbers like this, when we look at these numbers here that represent the GI Bill and its effects after World War II, it's tempting to think that we are seeing the birth of the American middle class, the modern middle class. But in reality, what we are seeing is an element of the birth of a white middle class. So is my point that my grandfather didn't work hard, that GIs like him didn't work hard? Absolutely not. Absolutely not, right? He sacrificed in ways that I will never sacrifice. I will argue until I'm blue in the face that he deserved every single free credit he got at the University of Toledo in Ohio. My point is that these men also sacrificed, right? And if we fail to acknowledge that what men like my grandfather received was a privilege, a white privilege in many cases, then it's a slap in the face to the men who also sacrificed, but might not have gotten the home loan or the seat in the class or the job training that they wanted. So in the United States, this idea of white privilege is not the opposite of hard work. In fact, in the United States, the kind of hard work that leads to a better life for someone's descendants has all too often been a form of white privilege. So that is a bit about what white privilege is not, right? But what is white privilege? Affirmatively, what is it? At this point, I think this presentation could go in 1,000 directions. There are many answers to that question. But I want to focus on white privilege and housing. And specifically, I want to think about, for me, my parents' house, what I sort of consider to be my family house. And if you all could see the house, you might think, that house of privilege, it's a very beautiful house, very nice house. But it's a suburban house like millions of other suburban homes across America, right? It's not some mansion in Rhode Island like we saw a picture of earlier. And yet that home was a source of stability for me growing up. It put me in a great school district. It's been a source of financial stability for my parents, continues to be in their retirement. Now, some of you might hear this and think, okay, well, can't anyone buy a house? How is this a form of white privilege? Or some of you might be thinking, wait, this doesn't apply to me. I don't own a house. I want to address both of those questions, but as I look at this idea of housing as a white privilege, I want to plug a book, right? Everything that I say from here on out, unless otherwise specified, comes from this book right here, The Color of Law by economist Richard Rothstein. Amazing book, unbelievable book. And so if anything that I say piques your interest, I really hope that you will buy the book, read it, and then give it to somebody else. So let's take a look at this idea of housing as a white privilege. And as we do, I want to focus on a few things. I want to focus on the ways in which the government has supported white homeownership, specifically white homeownership. I want to talk about the ways in which the government has devalued property in Black neighborhoods, and the ways in which the government has prevented African Americans from leaving economically depressed neighborhoods. So to understand this first concept, the government supporting homeownership, but specifically white homeownership, I'm going to give a very quick little history lesson here with apologies to any historians or economists for the gross oversimplifications. In the olden days, right, we're talking pre-1930s, if you wanted to buy a house, you typically did it in cash. There were exceptions to that. Some home loan programs existed, but usually we were thinking, 1 year home loan, maybe 5-year home loan. Major shift happened with the New Deal in the 1930s when the Federal Housing Authority went to banks and said, look, if you loan people the money to buy a home and you give them 30 years to pay it back, I know that sounds crazy, but if you do, we will guarantee these home loans, right? We will underwrite these home loans. So I think this is a kind of a key point in American history where for the middle classes, homeownership became feasible. It became something that everyday people realized that they could have for themselves. I think many of us are familiar with the concept of redlining, this idea that these home loans were not in fact available to everyone. And as this map here illustrates, in cities like Baltimore, banks would literally draw red lines around neighborhoods and specify who could and could not receive these home loans. I think what I was less familiar with until recently is the role the federal government played in redlining. More specifically, the Federal Housing Authority went to banks and said, look, we won't guarantee any of your loans if you give them in Black neighborhoods. We also won't guarantee any home loans in integrated neighborhoods. And just for good measure, we're not going to guarantee any home loans in neighborhoods that might integrate. So here you have the federal government telling the banks to draw these red lines, telling the banks to keep home ownership white. This was not a secret. This is not something that was uncovered decades later by forensic historians. This was in the manual. Right? This was an open practice, ostensibly to preserve the status quo and to preserve the value of white property. How far did this practice go? How long did it last? Well, again, let me give you an anecdotal example here. So in Berkeley, California, in 1958, Gerald Cohn, a white teacher, purchased a home, got a loan that was federally backed, and then rented the home to a Black colleague, Alfred Simmons. The fact that Gerald Cohn had rented a federally insured home to a Black colleague so angered people, it prompted an FBI investigation. And when the government determined that no law had actually been broken, the Federal Housing Authority banned cone from future government-backed mortgages. In fact, the head of the Federal Housing Authority in San Francisco took the time to personally send him an angry letter about this situation. So I mentioned this because, to refer back to a previous slide, this is not 1947 Mississippi. This is 1958 Berkeley, California. Not quite within my lifetime, but certainly within my parents' lifetimes, and in a place that has long considered itself to be very progressive. So the government has actively supported homeownership, but white homeownership, not homeownership for everyone. I want to turn now to ways in which the government has been complicit in devaluing property in non-white neighborhoods, especially African-American neighborhoods. And this has really been a function of local governments more than the federal government explicitly. So one way in which many local governments have done this is to place industrial waste sites, really any kind of polluting industry, in and around Black neighborhoods, right? In Black neighborhoods, often because municipalities perceive that those communities lack the political clout to push back, around Black neighborhoods to literally cordon off Black spaces, to separate Black and white spaces. Another way in which local governments have devalued non-white neighborhoods is through highways, road building. So most highway funds come from the federal government. And this is especially true of what was happening in the 50s and the 60s with massive highway expansions. The federal government would foot the bill, but local municipalities got to decide where the highway went when it came through their city. And where the highway went was not surprisingly through non-white neighborhoods. Cities would openly state that they were using these federally funded highways as a way to eliminate unsightly and unsanitary districts. That was not at all coded language for non-white neighborhoods. And there were cities in which significant portions. I think it was Miami, 40% of available Black housing disappeared due to highway construction. The government has also been complicit, if not, directly active in preventing African Americans, especially, but really all non-whites in some cases, from leaving economically depressed neighborhoods. So I'm going to give you two examples of this. The first is really an extreme example. And then the second is a subtler, more systemic example of this. So for the first one, in 1954, Carl Braden, a white man, bought a home in an all-white suburb of Louisville, Kentucky. Braden then sold his home to Andrew Wade, an African-American electrical contractor and Korean War veteran. So there's a picture of Andrew Wade with his family there. Basically, Wade had the money to buy a house. No one would sell him a house. So he worked out this deal with his friend Braden. Neighbors, when the Wades moved in, demonstrated for a month, kind of marched around the house, made a lot of noise, did everything they could to get the Wades to leave. Police watched on, didn't get involved. Demonstrators at some point threw a brick and fired 10 rifle shots through a window. When they still didn't leave, the home was dynamited. So you can see a picture there of, how they put dynamite under the home and it blew a bit of the home off. After this happened, the police chief acknowledged that he knew the perpetrators, but no one was indicted. And in what I think is one of the most bizarre twists of any story I've ever heard, Carl Braden, the white guy who sold the home to Andrew Wade, He was convicted of sedition and sentenced to 15 years in prison. Only person in this scenario to be indicted or convicted. His conviction was overturned, but he was incarcerated for some time as a result of this. So this is admittedly, as I said, an extreme example. I think it's important to note the ripple effects, though, of an example like this. When families across Kentucky, across the nation, see the government tacitly condoning this kind of really racial terrorism, when they see that law enforcement did nothing to stop it, when they see that the court system was complicit in it by indicting or by conducting a trial for Braden, that has a chilling effect on families moving out to the suburbs. Nevertheless, it's an extreme example. And I think many people would look at this and say, look, that's horrible, but that's not something that my family would ever have participated in directly. So I want to turn, as I said, to a more systemic and in many ways more insidious example of the government's sort of the way it's been complicit in suburban segregation, and that is to talk about white flight to the suburbs. And of course, if we're talking about suburbs, we have to talk about Levittown, right? Most of you are familiar with Levittown. This guy, William Levitt, had this brilliant idea that instead of building one house or 5 houses, he was going to build 17,000 houses. And because of that scale, he would build them cheaply, he would sell them inexpensively. He started this just outside of New York. He had a second one in Philadelphia. And then it took off across the nation. Because of the scale of this project, I mean, kind of pictures here would indicate you don't build 17,000 homes without financing from banks, right? William Levitt didn't have the money to build 17,000 homes lying around, obviously. We know from earlier, the Federal Housing Authority had told banks very explicitly, we won't back any loans that you extend to non-white neighborhoods. So banks told Levitt, we will not finance Levittown unless you can promise us it will be all white. Banks were saying that because the government was saying that to them. So as William Levitt said, we were 100% dependent on the government. He was not by any means a racial pioneer, not at all. But had he or the banks wanted to sell these homes to African Americans simply to increase demand and therefore, push up the price, they couldn't have. The government refused to participate as a loan insurer unless the suburbs were white. So after practices like this, what happened, right? What are the results that we saw in the 50s, 60s, 70s, 80s? What are the results that we're still living with today? Many answers to that question. But to just go through a couple of the sort of immediate effects, one was overcrowding in non-white neighborhoods. So as non-white populations were increasing, and yet the pool of available housing was in many cases shrinking, the cost of housing skyrocketed even as the quality of the housing diminished. In the 50s and the 60s, many non-white families, especially Black families, were paying more for housing than their white counterparts. The difference being the housing wasn't as good and they weren't building equity. This, of course, led to issues with schools, among other issues. Schools in historically Black neighborhoods, in many cases, became so overcrowded that school districts were telling students to only come to school on certain days of the week. On other days, they were just kind of out and about. School districts saw this as a better option than simply rezoning so that some of the non-white students would go into the relatively uncrowded white schools. Many of us probably experienced some ripples of this practice. I mean, I know that I personally went to a great school in Maryland. It was brand new when I went. Great student to teacher ratio, great education, I thought. It was also virtually all white. So this is something that many of us probably have experienced to some extent in our lifetime. And then, of course, there is the wealth gap. Discriminatory housing policies are a major factor in the current wealth gap that exists between white and non-white people today. If we think of wealth as what we own minus what we owe, for every $100 in wealth held by a white family, Black families have $10 or less. I emphasize or less there because that's probably the most optimistic take on the wealth gap that I've ever seen. And certainly in certain areas, the gap is much bigger than that. So for example, I've read in a couple of places where I live in Washington, DC, the wealth gap is 80-1. So what is the role between this wealth gap and these discriminatory housing policies that we've been talking about? Well, to understand that, it's important to note that in the 40s, in the 50s, in the 60s, we really saw a rare opening into middle-class home ownership. What I mean by that is this: in 1948, you could buy a Levittown home. This is a suburb of New York City for $8,000. What does that actually mean? $75,000 in today's terms. You go find me the home in a suburb of New York City that you can buy for $75,000. And if you do, like, call me, we'll work something out. We'll figure out a way to make this work. We'll split it up. It just doesn't exist anymore, right? And so when we look at what families who bought homes in the 40s and the 50s and the 60s, kind of what they're getting out of that over the generations, wealth accumulation adjusted for inflation, at least $200,000. And that's assuming they're selling their home for around $350, which frankly is absurdly low. I mean, a lot of, especially after the last couple of years, a lot of families could sell these homes for a lot more than $350,000. I mean, those are pictures of Levittown homes right there, taken recently. So you look at this and you say, okay, Luke, $200,000. Is that privilege? I mean, $200,000, that is not enough money to retire at 25 and spend the rest of your life drinking martinis by a pool. No, you're right, it's not. But it is the kind of money that might help you get a kid through college, right? It's the kind of money that might serve as collateral on a small business loan so that you can stop working for someone else and start working for yourself. It's also the kind of money that can help pay off debt, say unexpected debt in a time of crisis, the kind of money that can help families avoid financial disaster. And there was a very interesting article about this that came out several years ago called The Color of Debt by economists Paul Keel and Annie Waldman. They discovered that after adjusting for income, Black families with consumer debt in these three cities, St. Louis, Chicago, and Newark, were twice as likely to receive court judgments, really financially disastrous court judgments, as white families with the same amount of consumer debt. And so, one sort of quick interpretation of that is, well, the people seeking these court judgments, maybe the agencies, corporations that owned this debt, right, they must have been racist. What Keel and Waldman found was more complicated, right? When they looked into this, they realized that the owners of this debt very intentionally kept policies race neutral, race blind, I should say. And in fact, when they looked even deeper and would talk to people from these companies seeking these court judgments, often the employees perpetuating, these policies were themselves people of color. So what they realized when they dug deeper was, quote, that generations of discrimination have left Black families with grossly fewer resources to draw on when they come under financial pressure. In other words, it's policies like the ones that we've been talking about that have often given white families just enough cushion to, for example, be able to quickly access $3,000 or loan $3,000 to a child or to a family friend. And in many cases, the debt that put these families in a state of financial ruin was relatively low. It was $3,000 or less. So some of you might say, okay, that's interesting. That's, compelling interest that homeownership has been a form of white privilege, but wait, I don't own a home. My family has never owned a home. I think this brings up an interesting concept, and that is the idea of proximity to wealth versus wealth. So if you want to predict how materially successful a person will be, and of course, by materially successful, I mean things like how well they'll do in school, how much money they'll make, how long they'll live. The best predictor of that is not necessarily the wealth of an individual or a family, but rather the wealth of a community. It's more important if what you're going for is material success, it's more important that you live in a wealthy community than that your family have wealth, although neither one hurts. With that in mind, it's interesting to read a statistic like this. Young African Americans have a 66% chance of living in a, quote, poor neighborhood, defined by percentage of people living below the poverty line. Young whites have a 6% chance. So this doesn't mean that 66% of young African Americans will live below the poverty line. That's not the statistic. It doesn't mean that 94% of white people are rich. What it means is that the vast majority of white people born today will live in a community that has collectively benefited from the policies that we've been talking about. And that is the number one indicator of material success. There's also this idea of association with wealth. And now we're really getting into psychology, sociology, things that I am not even remotely qualified to talk about. So I'm, one slide, I'll make the point quickly and move on. But it seems to me that if all it takes is, apparently a suit and a good haircut, and suddenly you are associated with the wealthy class, with the landed class, so to speak, that is in and of itself a form of privilege, something that people can capitalize on for their entire lives. So when we think about white privilege, and I say we, especially to mean, myself, white folks, I think we often picture this, and understandably, we reject the association. We say, that is not my family. That is not where I came from. That's not me. And that may be true. But as I said before, if we want to talk about white privilege, honestly, systemically, for many of us personally, I think we need to picture less of this and more of this, more of the homesteading pioneer, more of the American GI, more modest homes in the suburbs. To borrow a concept from Martin Luther King, Dr. King said, "It's fine to tell a man to lift himself up by his bootstraps, but it is a cruel jest to tell a bootless man to lift himself up by his bootstraps." I think what I would say in parting is this: white privilege doesn't mean someone didn't lift themselves up by their bootstraps, right? White privilege doesn't mean you didn't lift yourself up by your bootstraps, doesn't mean your family did. White privilege means you had bootstraps. Thank you very much. And I will turn it back over to our moderator.
Thank you, Professor Fredericks, for that history and all that information. And thank you, Joyce, for the background of how this is going to tie into ADR. I have like all these new tabs open on my browser, everyone. Thank you. Now I have like Harvard's project, Implicit, African-American Exodusters, the Color of Law book that you mentioned, and lots of things in the chat. So for everyone that, if you haven't read the chat, we're going to take a break shortly and make sure to roll through the chat. I saw multiple endorsements for the book that was brought up, and lots of links to things and comments that are helpful if you guys want to look through the chat during our break. But before we go to our break, I am going to introduce the handful of next people we're going to have talking. We have 2 trainers and we have 3 panelists. So we're going to do our break shortly after I introduce these folks. And then when we come back, we're going to have our panel discussion with the 3 panelists that I'm going to introduce, and our trainers are going to moderate. And then we're going to have another break, and then we're going to do our training with a scenario breakout. And we're going to tie in what you heard from Joyce this morning about the role to this white privilege that we just learned about, and how we can take all that information and what we can do with it in our ADR practices. So our trainers today are Dr. Shauna Payne-Gold and Tara Taylor. Dr. Shauna Payne-Gold is the founder and owner of Gold Enterprises, LLC, and she provides inclusive strategic planning, educational sessions, executive coaching, and facilitation services for aspiring multicultural and anti-racist organizations, and has held progressively influential roles in higher education, leading up to assistant provost and for diversity and inclusion and professor. She is an award-winning consultant, coach, administrator, entrepreneur, and difficult dialogues facilitator, and has had many recent honors, including being named as a 2022 Movers and Shakers for being a co-host of the Unfazed podcast for you all to check out, which has more than 80 episodes. So thank you, Dr. Gold, for joining us here today. And then we have Tara Taylor co-training with her, and Tara Taylor is the managing director of ADR Vantage, Inc., where she specializes in conflict management, organizational effectiveness, and leadership development, training and facilitation, and she leads the firm's diversity, equity, and inclusion practice. So prior to going to ADR Vantage, Tara worked for the Maryland Commission on Civil Rights. So she's a local for almost 20 years. And she was the mediation program director there, and then the education and outreach director. And she also was the co-founder and former director of the Maryland Equity Inclusion Leadership Program, and was the former chair of both the MPME committee that you all might be familiar with, and the Maryland ADR Program Managers Roundtable. So she's a dynamic speaker and trainer focused on helping audiences engage, get inspired, and walk away with ready to implement solutions for any professional challenges. So Dr. Gold and Tara are here to help us kind of put all this together and what we're going to walk away with at the end of the day. And then we have our 3 panelists here. We have the Honorable Dennis M. Sweeney, who is a senior judge who is still sitting with the courts with criminal and civil cases in the various counties. And he also is a private mediator and arbitrator for JAMS in the DC office. And he also mediates with the Court of Special Appeals ADR program. So I get the pleasure to co-mediate with him from time to time. And so prior to retiring, he sat full-time on the bench and was one of the first judges appointed to the Maryland Business and Technology Case Management Program. And he currently serves as a member of the Judiciary's Alternative Dispute Resolution Committee and the Senior Judges Committee. And our second panelist is Jeff Truman, who is an experienced full-time mediator and arbitrator, does this privately. Helps parties resolve all kinds of disputes and pre-suit disputes, but also court cases, involving catastrophic injuries, wrongful death, professional malpractice, employment, business dissolution, real property is his expertise. And he is been published in multiple different arenas. You guys, if you want to read his bio, can see some of the places where you can find his work. And beginning this summer, he is going to serve as an adjunct professor at the top-ranked Strauss Institute for Dispute Resolution at the Pepperdine School of Law in Malibu, California, which is where we go for a ton of our classes because they are awesome. And then we have Michael Lewis, who is an arbitrator, mediator, ombudsman, court monitor, and special master, and has worked in dispute resolution for more than 40 years. So we have a ton of experience here. He does his neutral work through JAMS, also based in DC, and has taught mediation in the Harvard Negotiation Institute, another place that's great for ADR classes, for almost 30 years, and then mediation and negotiation at Georgetown University Law Center for more than 20 years. He had prepared lawyers to mediate in federal and state courts across the country and has trained mediators in Canada, Australia, Jordan, New Zealand, Germany, and Norway. So that's just a brief intro to the people that you're going to be hearing from after our break, because they have a long list of accomplishments that you all can find more in their bios in the program that was attached to the email that you all got with the link to sign on to Zoom today. So check out that email. Angela also posted it in the chat at the very beginning. If you want to scroll all the way up, you'll be able to find a link to their bios as well as our program if you want to follow along with the agenda for today in terms of timing. So that takes us to our break, unless Tara and Dr. Gold, do you have anything that you want them to think about before we go to the break?
No, I think we want everyone to take a break, right?
Yes.
Stand up, move around. And Katie, we're back in about 5 minutes. Is that right?
We have about 15
Oh,
minutes.
we're gonna do
So
our
you
15.
guys get a big stretch break because we just gave you so much information, and maybe you opened up tabs on your browser too, like I did. So we are going to come back at 1:25. And that's when we're going to start our panel discussion moderated by our trainers. So 15 minutes, back at 1:25. We are going to jump into our discussion promptly at, again, 1:25.